Good afternoon, everyone, or good evening, depending on where you're joining this session from, and welcome to the first session of the 6th Moscow FIAMC conference on how to detect sabotage in the process. For a moment, we only have one speaker, Timothy Nelson, who I'll introduce in a second, and Philippe will be joining us very shortly. But let me just start with thanking the Russian Institute of Modern Arbitration and the Russian Arbitration Center for hosting this event and gathering really star speakers, both on this panel and on the following one. Perhaps while we are still waiting for Philippe to join, a few words on the topic that we're going to discuss today. In this first panel, we're going to speak about bad faith conduct in arbitral proceedings and how to detect and neutralize the sabotage in the process of at various stages of the proceedings. It is undoubted that every arbitration practitioner has at least once experienced something like an out-of-nowhere provisional measures request submitted on the Christmas Eve, or opponent's counsel consistently misspelling in procedural correspondence the names of all of your team members, or omitting to copy some of them altogether, or a witness who is perfectly fluent in the language of the arbitration suddenly requesting an interpreter for the hearing simply to break the flow of the cross-examination and take more time allocated to your side. However, the reason we are having this discussion today is that sometimes counsel's misconduct goes much further than that, and it is this more serious dirty tricks and techniques that are used in order to gain unfair procedural advantage that we're going to speak about today. And we now have with us Philippe Pinsolle, and let me say a few words about the speakers that we have today. We are privileged to have Timothy Nelson, a partner at Skadden, based in New York. Good morning, Tim, if you're joining us from New York. And Philippe Pinsolle, head of Quinn Emanuel's International Arbitration and Continental Europe practice, who is same as me, based in Geneva. Hi, Philippe. If you don't know Tim and Philippe already, I do encourage you to look them up and study their impressive biographies and long lists of cases that they have dealt with. That will reassure you that we are lucky to have them today to share their thoughts and experience on this topic. A few remarks on the format. So we'll have two parts today. We will first speak mainly about guerrilla tactics in general and in written communications specifically. And for that part, Tim will be our, let's say, main speaker. And then in the second part, we'll focus on the same, but in relation to evidence production specifically. And we will discuss that with Philippe in particular. The idea is, of course, to have an interactive discussion. I'm mindful that often this format is declared, but not precisely followed. So we'll make our best effort in keeping the discussion lively and interactive. And for that, we encourage your questions. So please do drop your comments, remarks, and questions in the comments, and I'll pick them up and put to the speakers either right away or at a later point. So that will be that for the introductory remarks, and I believe we can move to the discussion now. And I'm giving the floor first to Tim, who will walk us through his experience with guerrilla tactics in arbitration. Tim, perhaps you could just tell us a little bit more about which tactics you have encountered in your practice.
Thank you very much, Anna, and thank you for your kind words of introduction and for the opportunity to join you and your friends and colleagues here today. Can I just begin by saying that, and I don't know if Philippe has a different take on this, but I suspect he'll say something similar. The term guerrilla, it's I think a Spanish word that was coined some years ago, and it refers to a kind of military tactic in asymmetrical warfare or uneven warfare. The term guerrilla tactic is a loaded term. There are some tactics that the, quote, underdog or the disadvantaged party, or the party that in some way disagrees with the process. There are some tactics that a disaffected party can take that are legal and legitimate, but will be extremely unpopular with the other side. And I distinguish very much between zealous but legitimate efforts to defend a client, which sometimes might even seem innovative or unorthodox, right? That's on one side of the line. And on the other side are overzealous or illegitimate steps that, in the eyes of an objective observer, do not have a good faith basis. And the reason I'm very careful about this is that often the word guerrilla tactic is thrown around by an opponent who just doesn't like the tactics the other side is using, even though the tactics are legitimate. Okay. So naturally, I've seen both in my career, as I'm sure you have. But it's really the latter one, the behavior that crosses the line and doesn't really have a good faith basis that we're here to discuss. And it's rightly called sabotaging tactics as well. And you know it when you see it, I like to think. And there's a whole array. The sad truth is that the possibilities for illegitimate tactics are only limited by human imagination. So they're quite unlimited. And they can cross a whole range of possibilities. One is boycotting an arbitration entirely, although in a sense that's the least harmful. In the sense that's the most intellectually honest thing to do. If you, for whatever reason, do not think that you are bound by an arbitration clause, the intellectually honest thing might be, in some circumstances, to not appear at the arbitration. I mean, it's hard to say that that's, in a sense, that's not sabotaging the arbitration, because there are mechanisms and rules for the arbitral tribunal to be constituted and for the arbitration, nevertheless, to proceed. The institutions, the ICC, AAA, LCIA, etc., usually have the power to fill vacancies on a tribunal. There are a few cases in public international law. There's a case called the Romanian Peace Treaties case that is a Cold War case where, unfortunately, the clause required both parties to appoint an arbitrator, and it was easy enough not to appoint an arbitrator, and then you don't have it proceeding. But for the most part, it's boycotting in its purest sense doesn't really have much of an effect. Walking out of an arbitration halfway through is another kind of tactic, and that's a little bit more destructive. But again, that doesn't always have the desired effect. Meritless challenges to arbitrators is a little bit more, I think, in the sabotage and can cross the line into bad faith, and I'll get into that. And then what I would call the more petty tactics around dates, deadlines, written submissions when they go in, that kind of thing. And as you correctly said at the outset, that can slide into even microaggression, things like misspelling people's names in the papers. And then of course there's other things. There's collateral litigation to enjoin the case. There's malfeasance in the presentation of the case. There's discovery misconduct, and then there are some really, some absolutely egregious things that can go on from time to time, and the use of surveillance and against the other side, or there are cases where people forget or willfully ignore that arbitrators are supposed to be independent, and that is the ultimate form of sabotage of the proceeding that I think everyone would agree improperly influencing an arbitrator is way beyond the line. Anyway, and in many cases illegal. So that's the spectrum of things. And, usually I think when we're talking about guerrilla tactics, we're talking about things that are sort of in the middle of that spectrum, not the absolute worst, but that's what I've encountered.
Right.
Sorry.
So thanks, Tim. So if you would look at this spectrum in your personal experience, and maybe you can compare your arbitration experience, your litigation experience.
Yeah.
What guerrilla tactics do you find most difficult to deal with, or like the most problematic?
Yeah, it's good you began with that, because in litigation, right, in national litigation, say in the United States, you always have a safety factor, because doing things that interfere with the justice system clearly implicate the court's contempt power. And they can literally throw you in jail for contempt. I mean, there's an old joke that, you know, if you're in front of a judge who's annoyed with you, pack your toothbrush, because that's when you get sent to jail. You're allowed to keep your toothbrush, but nothing else. In arbitration, there is an unfortunate belief amongst some that because they don't have the power of a judge to police contempt, that people can do things that they wouldn't do in litigation. That's part of the general problem. But, you know, that's where you have to be careful. And you know, the kinds of things that most annoy me are around that kind of presumptuousness, that you can get away with it. And arbitrators actually do have the power to sanction. They have the power to default a party, to say that the party has misconducted itself enough that it loses the right to defend its case going forward. They have the right to declare that a deadline has been missed and the default can't be cured. They have a number of reserve powers. They don't always exercise those powers for reasons I can discuss, but the underlying problem is that people think they can get away with this kind of misconduct. And there are ways of dealing with it, which I'm happy to talk about, but that's...
Yes, it would actually be interesting to hear, because you're touching on something which, yeah, I think is not a surprise to everyone, that sometimes it feels there's this presumption of flexibility of deadlines in arbitration, or that there will be no real consequences of failure to abide by the deadlines. So what do you think are the reasons that the arbitrators are reluctant to impose sanctions in those cases?
At the very beginning of every case, the arbitral tribunal wants to make clear to both parties that it will give them a fair hearing. That is sometimes abused. That goodwill is sometimes abused by parties because, for instance, giving somebody a fair hearing and giving them their proverbial day in court means that they get to present their case, right? Now, if parties are conducting themselves properly, the claimant puts in their written memorials and their witness statements, and the respondent puts in their written memorials and their witness statements, and then the parties cooperate and there is a hearing. It might be a virtual or real, and the parties present their cases live and the witnesses are heard, and then the arbitrators make their decision. Until that decision is made, the arbitrators are not supposed to prejudge the issues, right? And here is the problem, right? A lot of arbitrators are worried that if they impose sanctions or discipline on one party before that hearing or before that award, that somebody will say, oh my goodness, you've prejudged the issues or you've shown favoritism to one side. That's actually not the case. If you have a party that chronically fails to meet deadlines, an arbitral tribunal has the power to exclude, future submissions from that party. They have a number of reserve powers. And look, the reason that hopefully default or boycott is exceptional, and the other part of this equation is the reason most people behave themselves and don't engage in guerrilla tactics or sabotage is, even though arbitrators don't prejudge the issues, they see things going on. So if they see one party presents its case in a responsible manner, turns up and meets every deadline and comes to the hearing and is honest, and the other party is evasive and slippery and late, and there might be problems in the way that they produce documents, or there might be discrepancies in the witness statements, all of that counts against a party in the eyes of the arbitrator. That destroys their credibility. And there's a phrase I like to use, although it has some ironies attached to it, from a historian called Hugh Trevor Roper, who once said, credibility is indivisible. Right? The ultimate deterrent ought to be for parties against engaging in improper tactics is that they will lose the case, right? If the arbitrators think that they have misconducted themselves or behaved in a less than credible way. And where you have a party engaging in this kind of tactic, all too often, the result becomes obvious. The result of the case is if you're having to resort to these tactics, you must have a weak case. The arbitrators think the case does prove to be weak, an award is rendered, and then you're in an enforcement fight. That's the usual way that these things play out. And that's the usual deterrent. But arbitrators have the power through moral force, through the strength of commitment of the three arbitrators themselves, through clear communication to the parties, and by the chair sometimes having a very candid statement to both counsel, but usually directed to the party who's misconducting themselves. Don't do it. It doesn't help your cause. It doesn't help this process. It won't be appreciated. Another thing that can happen is that arbitrators can award the fees and costs associated with misconducting an arbitration against the party who's engaging in the wrongful tactics. Herein lies again the problem. If the misconducting party or the sabotaging party is doing it because they know they have a weak case, they've probably calculated that they'll end up having to pay the other side's fees anyway. So, sometimes you have a party who is coming to the arbitration almost in a defeatist posture, thinking that I have a bad case, but I can obstruct the process. And that's the most difficult of the opponents, because they've already decided it doesn't matter that they're coming across without any credibility.
Yeah. It would be actually interesting to hear Philippe's thoughts on that as well, because you've been in a position of the arbitrator many times. What would be your approach to the party that disregards deadlines, or if you see some variation of guerrilla tactics going on with regard to the deadline specifically?
Yeah. First, I shall say that I fully agree with Tim's comment at the beginning. It is one thing to defend, fiercely the party you represent. It is yet another thing to engage in guerrilla and obstructing tactics. Now, speaking of deadline specifically, the only thing that I can say is that when I was at the IBA Arbitration Committee, we conducted a study in 13 jurisdictions on due process, and it's still available online. And there is not one single case of an award being set aside because the arbitrators have excluded submissions that were not filed in due time. So it means that if you exclude the submission that is filed late, nothing happens. And the question really is for arbitrators themselves to make clear to the party that any submission that is out of the deadline, if it's something which is a pattern, of course that can happen once, no question, and you can always request an extension. But if it becomes a pattern, then you can exclude the submission and decide the case, and your award will stand. Because judges do the same, so they know it perfectly. And really, it's for arbitrators to react rather than for parties themselves to or to expect that some parties will behave. If they have decided to engage in these tactics, it's not even a cost award at the end that will change their mind, because it's a calculated decision in that case.
Exactly.
So, yeah.
Thanks, Philippe. We have a question from the audience, and maybe it would be a good moment to bring it up. It's a question from Petya Kocheva. Is there an intersection between the sanctions imposed on parties in respect of misconduct and any sanctions imposed on the legal representatives related to any such misconduct?
Yes and no. If you have a party that is misconducting itself or sabotaging the proceeding, in my view, right, the most effective sanctions are against the party itself. No matter how frustrating the counsel may be, the opponent is the opponent. Okay, so I always begin by thinking that the most effective sanctions are those directed against the party, and it gets to Philippe's point that you do have the power to cut off submissions and say you're late, you've missed 3 deadlines, you're no longer defending this case, you're in default. That is a sanction against the party. Okay, so I have had several cases where the conduct of counsel became an issue ethically and legally. And in one case, which I won't name, but I was involved in for quite some time, the counsel was held to have misconducted himself as the firm in the post-award proceedings and in proceedings collateral to the award. And in the United States, there is, in addition to having a power to sanction parties for misconduct, there is a specific statute, 28 USC 1927, which permits a lawyer to be the subject of sanctions for vexatious or oppressive repeated conduct. And you can obtain quite effectively monetary relief in the form of a fees order. People think the United States is a no-fee jurisdiction, and it largely is, except under the statute and except in the inherent sanctions power. I will say, though, right, I get back to what I said earlier, right? There are, and I'm no longer talking about the case I was doing in the United States, by the way, when I'm saying this generally. You always have to remember as counsel who the real opponent is, right? I've had many conversations with clients where they say, you need to go after that lawyer. I don't like that lawyer. He's doing things I don't like. I'm saying, yeah, but you know what? Maybe I do, maybe I don't, but just remember, he's actually not your opponent, or she's not your opponent. Remember who you're suing, right? Because it can become a distraction to focus too much on counsel when sometimes the real malfeasance is being practiced by the opposing party, right? And anyway, that's the practical thing, because counsel can distract from the real issues in the case and the real imperatives of the case.
Yeah, it's actually interesting to point out in this context that the new version of the LCA rules takes that direction, and that now there is a power of the tribunal to sanction the counsel as well for an abusive process, also in the context of the document production. Of course, there is no financial penalty that can be imposed. It's more in form of a warning, let's say. But still, it's interesting that this relationship between the counsel and the tribunal is exploited a little bit more in the recent version of the rules.
Yeah, if I can make a comment, you have to be extremely careful as a tribunal if you start distinguishing counsel from the party, because you have jurisdiction over the party, but not over counsel, taken separately. You're not a court. Court have, of course, inherent jurisdiction against everybody, and they can sanction counsel. Arbitrators derive their powers from agreement. The agreement is between the parties. And so the counsel is merely, as Tim said, the representative of the parties. So don't get distracted. He is absolutely right. It is the party. And for the tribunal, it is the same. It is primarily the party. I know that some rules go the other way. I'll be very prudent as a tribunal to exercise that power and to drive a wedge between the party and the counsel, because you may enter into a fight with one party and then you end up being challenged and the challenge being sustained. I mean, that's a trick of certain parties to push you to the limit in order to challenge you successfully.
Yeah, that's a great point. Thanks very much. We have another question in the chat, if you would like to maybe take it first. From David, would you consider deliberate prosecutor-style bullying of the witness or expert during cross-examination as an attempt to sabotage or otherwise affect in bad faith the arbitral proceedings? What's your views?
Well, if you want me to start, Tim may have a view, and surprisingly, I think we will agree, actually. Cross-examination is not meant to be a pleasant exercise. It doesn't mean that you don't have to be courteous, but it's not meant to be nice. You're not meant to be nice. It meant to elicit evidence. So I belong at least to the category of people who think that cross-examination is acceptable. You can, let's say, be firm with a witness, especially if the witness is not cooperative. But you have to be courteous, and you have to be consistent or be within those questions that are relevant to the case. And the relevance issue for me is the most important, not so much the style. Of course, if you start bullying the witness in a real sense, then the tribunal will intervene, at least in my experience, will intervene immediately, and it will not assist your case, frankly. Tim, you may want to supplement that one.
Yeah, I think the last point that Philippe made is important, that if you want to, if you're engaging in cross-examination, whether it's proper or improper, you're doing it in full view of the tribunal, and the presiding arbitrator often intervenes if there's a patently abusive question. So in terms of things that are likely or unlikely to sabotage the proceedings, right, cross-examination is actually less likely to be effective because it'll be stopped if it's abusive. I also agree that cross-examination is meant to be a robust questioning process. I'm a common lawyer, have, for 30 years in the Australian or English or American systems. I have my own view that cross-examination needs to be robust and sometimes aggressive. And by the same token, I have my own very clear understanding that there are some kinds of questions that are abusive and shouldn't be allowed. And for instance, replowing the same issue again and again and again is just not something that is useful, and haranguing a witness for no reason or implying that they've engaged in fraud or criminal conduct when there's no good faith basis to do so, all of that should not go ahead. And there are actually ethical constraints on counsel that ought to prevent those things happening at all. But I have to say that there's some things about testimony that are actually more likely to compromise the integrity of the proceedings. I think witnesses who, witnesses who cheat, in a sense, who don't tell the truth, witnesses whose testimony varies dramatically from their witness statement, or who come up with new memories or recollections that don't appear in the witness statement and sound like they've been invented recently, are actually much more destructive of the process. And maybe that's me as a cross-examiner. I have
and that's another issue, whether a witness can sabotage the proceedings and not the counsel.
Yeah, I think that's equally, if not more important, to look out for.
Right. Maybe just like wrapping up on this first part about the sabotage of the proceedings. So Tim, what do you think is the best way to counter as a counsel? What's the best weapon against all this various guerrilla tactics that your opponent may use?
Vigilance and teamwork on your side. Read everything they've written in their submissions. Be awake to the risks. Be conscious that at every stage, disclosure, the procedural conference, at every stage, there are points where procedure could be put at risk by an irresponsible party, and be vigilant every time. Have people on your team who are experienced and have seen it all before. And, anticipation and also just know your forum, know the right remedy. One of the things that you need to know whether your tribunal is likely to sanction or control the other party. Because one of the worst things you can do if you think the other side is about to do something bad is to lunge and ask for sanctions or ask for some sort of draconian remedy. You either are doing it too early or you're doing it in front of a tribunal where you ought to know they won't give it to you. You know, that can, so know your forum and know the limits of your forum is a very important thing. All of that is judgment, right? All of that is experience. And as I say, you know, in sovereign cases where you're against or representing a sovereign, investor state cases, there's a whole array of things to watch out for that might be different from litigation between private parties, but be aware of all. Awareness is the main protection.
Certainly. Yeah, it's very interesting that you mentioned like the best moment to raise guerrilla tactics with the tribunal, because often it will be a consistent conduct which you maybe as a counsel already see early on, but as you said, maybe it's too early to raise with the tribunal or ask for a specific remedy. Do you think it still makes sense to at least flag to the tribunal or like object, even if you're not asking for a draconian remedy yet, of like excluding the whole submission?
Yes, and I'll use an example that is, the following example is from a real case, and it's not really guerrilla tactics, but it's a good example. Mm-hmm. If you have a procedural conference 10 days before the hearing, and if you suspect the other side is going to come in and try surprise tactics in the opening with new authorities or new evidence, right? At that procedural conference 10 days beforehand, you should have something prepared. And you should say, Your Honor, presiding arbitrator, I just want to make clear, can we all agree today that the evidence is closed and that no additional witness testimony or exhibits will be introduced from this point forward, and that no new legal arguments will be made from this point forward? And I know that's in the original procedural order number 1, but I thought it would be important to stress this, right? Because if you say that 10 days before the hearing, and the hearing begins, and the first thing the other side does is introduce new evidence and new authorities, you got them, because you say, just a sec, we had this 10 days ago. I mentioned this, and everybody agreed, we were done. And what's this? This is new, right? Works a charm.
Yeah, exactly. That's, I think, what I had in mind too. Thank you very much, Tim. I guess we can be, unless any further remarks from either of you on the sabotage, anything else you would like to add or share, we can maybe pass on to Philippe, who would focus on the sabotage practices or abuse of process in document production phase. What would be the main forms of abuse of process at that stage of the proceedings, Philippe?
As we said, abuse is a very high threshold. So it's the same caveat I have as Tim had at the beginning. There are, ways of doing things which are less than ideal, which will not necessarily assist your case, which may drive the other side crazy, but these are not abuses. And so if you look at the document production exercise and the use of documents in general, many people tend to focus on the reaction to a document request and objections to it as being abusive. But I would like to start with something which is upstream of that, is that you can have, and there's a question to this effect, you can have document requests which are themselves abusive. Of course, you can overflood the other side with many document requests. That's not necessarily an abuse, but it will not assist you. But it is a possibility. But quite often, it happens that you have documents requests made for an illegitimate purpose. A party is trying to obtain documents that may be relevant to its case, but for another purpose. It may be for a commercial purpose because it's illegitimate. It may be for knowing a business secret of the other side. It may be for another case that is parallel, not this one. It may be for a competition law action elsewhere. You don't know. So there are reasons for asking documents which may not be related to the case, which can be on occasion abusive and are not necessarily captured by confidentiality on the other side. So that's one aspect. The other aspect is most of the use of document. It is quite often, or it is found in cases against states, against sovereigns, when there is a criminal element in the case. And in that circumstances, very often you will find a state issuing an Interpol red notice or things like that and asking for judicial assistance from other states, getting documents through judicial assistance or criminal proceedings. Generally, when you get those documents, you are meant to use them for the purpose that you gave or represented to the other state when you obtain the document. It's called, in French, the principle of speciality. So I ask document for the purpose of my own criminal proceedings, and then you can use them for that. But very often you find them in the investor treaty arbitration. And here, in my experience at least, tribunals are not very firm on that. They'll say, oh yeah, too bad, the states had those documents. Maybe they were initially obtained for another purpose, but nonetheless, they can use it. And then, of course, you have to deal with it. But that could be viewed as abusive. Similarly, this is a private party. It's a party using documents that were either illegally obtained or that are of dubious origin, left on the printer. You don't know where they come from. They tend to be documents from the other side, but you cannot justify the provenance of a given document, and nonetheless they are used. These can produce effect, even though initially it's very difficult to, let's say, give a legitimate tracing to the origin of the document. So here you have examples of a party either requesting or using documents in an abusive manner. I'm not talking about forged documents, because currently I have a case where there are forged documents, which is yet another type of abuse, of course, but more easily detected. At least in my case, it was easily detected. But you have all spectrum, as Tim said, of behaviors from parties using or requesting documents that could be abusive. Of course, on the other side, when you respond to a document production request, there are also tactics which could degenerate, as we say in French, to an abusive behavior. For example, you do not challenge any given document request, but there are no documents, and surprisingly, 6 months later, some documents will pop up. Or you do not challenge and you flood the other side with irrelevant documents which are actually not responsive. But of course, the arbitrators are forgotten by the time the other side has studied the documents. There are many of them. The arbitrators say, we decided the document production issue is too late. I mean, don't come back to us to that. It was not challenged. You got documents. They may be irrelevant. That's your problem. So that's one way of avoiding it. And I've seen it done, unfortunately. So that's relatively easy. Then, of course, you can claim confidentiality in an abusive manner. You can claim privilege in an abusive manner. I've been once appointed what people in the common law world call privilege master in a treaty case. My role was simply to decide whether documents were privileged or not. I was appointed by the tribunal with the agreement of both parties. I did that initially for confidentiality and then for privilege. It was an interesting exercise, I have to say. It's easy to abuse privilege or confidentiality. It's even easier to abuse redaction of document. You receive documents, but they are redacted, and you cannot figure out what they mean, or you cannot make use of them. And those small abuses are more difficult for tribunals to sanction. I will maybe stop there, Anna, because I've given many examples, and in the interest of the discussion, I could give more, but maybe Tim wants to supplement examples, I don't know, in his own experience.
It's human imagination again. A tribunal has the power, and Philippe is talking about when it's been exercised, to direct both parties to produce documents that are relevant to the issues in the case. And this is, in some senses, imported from the common law procedure of discovery of documents. In some senses not, but that's where I come from, at least. I understand it to be a form of discovery of documents, and I explain it to my clients as such. Now, a client might say, why should I hand over emails, texts, internal memoranda, especially if they look bad or they're embarrassing? If it's litigation, my answer is, if you don't, you're committing a contempt of court, and you may even be committing a worse infraction, and it's illegal. So I don't want to hear that it's embarrassing. You have to turn these things over and let me help you. If it's in arbitration, the same principles ought to apply. That it's a legal obligation to produce documents, even if they're embarrassing. But the reason, and the thing that arbitrators have to look out for, the reason it's a very bad idea to engage in discovery misconduct is that experienced arbitrators will tell that you've withheld important documents. If you tell an arbitrator, I didn't send any emails, or I don't have any emails because I don't use email, the other side is likely to produce a bunch of emails that you've sent to them. Oh, so you don't use email apart from the 50 emails you sent me, right? And the result of this is you lose credibility. Again, credibility is indivisible. It is the currency of the realm. In the United States, in front of a judge, if you're perceived as having withheld relevant documents, you don't just face sanctions. You probably lose the case. And in arbitration, I think that continues, when it's done well, continues to be true. If you have withheld relevant information and not been forthcoming, the arbitrators can usually tell.
Yeah, I agree. And also technically there's a big difference if you respond, the document does not exist, or we have not identified any responsive documents. Because with the latter answer, which you are well advised to use when you're, let's say your client is not familiar with the process and may or may not have conducted a full research even with your assistance. At least with the latter, you preserve a possibility to use responsive documents later if you have a good explanation as to why they were not produced in time. When you say they don't exist, that's it, they don't exist. If they exist, you're in trouble. So.
Right. Yeah, so you're both basically saying that in a way it's easy in arbitration to maybe, if not get away, but at least commit the abuse of process and document production, or clearly easier than in litigation?
It's a temptation, but the consequences are can be severe.
I agree. It's easy to conceive, but you usually regret the decision.
Yeah.
So like in terms of tools that arbitrators can use to punish or sanction the abuse of process and document production if it does get revealed, I guess the main tool would be the adverse inferences, something that Tim, I guess, meant by saying that you lose credibility and in the end the arbitrators just decide the case against you, or the award on the award on costs. So do you think that the adverse inferences specifically, or award on costs, are sufficiently effective sanctions in this context?
I think adverse inferences are far more effective, frankly, than a cost award. As I said, the prospect of a cost award for a party that is not playing by the rules is not a real sanction, because they will try to avoid paying the costs anyway and paying the award anyway, and it's just the beginning of a big fight. Adverse inferences, provided that they are tailored to the breach. I mean, again, it's not you lose the case altogether. It means that this particular point that could have been proven by the document is deemed to be proven, and you have to be slightly technical when you issue an award on adverse inferences, and for counsel to request for adverse inferences. It's just in general. It's not, sorry, in general. It has to be specific, and the more specific it is, the more likely you are to get and obtain your adverse inference. But if, again, it's a question of courage for arbitrators to render an award based on adverse inferences. I have once, it's slightly different, but a witness was clearly lying and was exposed as lying, and I put it in my award because I said, judges do that all the time. I see no reason why I shouldn't do it because I am an arbitrator. And so I did it. I was sole arbitrator. It was easier. Maybe in a tribunal of three, we would have been more, let's say, diplomatic in the manner in which the case, not the outcome, but the reasoning. But I thought it was actually a service to be rendered to the parties. The counsel was horrified, of course. But there's nothing you can do. I mean, you cannot get away with it. That should be the message, really, in my view. I think Tim would agree with that too.
Absolutely, but I think it's also, you can catalog the technical defenses or the technical sanctions that can be engaged here. But it's like I'm on camera. I think of the Robert De Niro character in Meet the Parents who goes, "I've got eyes on you." You know, everything you do in an arbitration is in full view of, or most things that you do are in full view of the three arbitrators, and that happens from day one, right? So, you know, if a party says on day one of the procedural conference that, you know, members of the arbitration, we're going to be coming to this tribunal and you're going to get full transparency from us and you're going to see everything about this case and we'll be completely cooperative. And then for the next 6 months, that proves to be a lie, right? And they've been obstructive. And you get to the first day of the hearing, that's a horrible position to be in on the first day of the hearing, right? And if the witnesses behave, you know, you used the example at the beginning of the witness who insists on translation, but is actually, say if it's an English language, you know, actually an English language fluent person who's just using a translator to slow things up. I have to tell you, I've seen that a number of times. Fortunately, it's never been my witness, right? It's incredibly difficult to hide the fact that you're fluent in English if you're in an arbitration where the lawyers are talking and the tribunal. It's really actually very difficult. So if you're a Japanese or Russian or Spanish speaker and you actually understand everything that's been said around you, it's very difficult to pretend that you're not understanding it. And I've actually had a case where the witness claimed to need a translator but was whispering corrections to the translator because he understood the language better than the translator. And the arbitral tribunal heard it. And guess what? The witness's testimony wasn't accepted. You know, the tribunal, I don't think, was quite as forthcoming as Philippe. I don't think the award said that he was a liar, but it didn't matter in the end. And they thought he was a liar. And the translation stunt didn't help. So that's, at the end of the day, right? Sometimes I sort of get angry a lot about sabotaging tactics because they end up sabotaging the party who's engaging in them, right? Why are they doing this?
Yeah.
I agree. And another way of dealing with it, which will work, let's say, 80 to 90% of the times, is when you see one party starting to engage, for example, in abusive redaction of documents. You can see that. You give an order and you say you can redact this and this and that and nothing else. And then everything is redacted. It is worth confronting that party in a procedural hearing, which can be done by Zoom, saying, look, are you very confident that your redaction are consistent with what we ordered? I mean, it's entirely up to you, but it seems to us that you may want to revisit that. And if you do that, you will see, let's say, maybe not 80%, but half of the time at least, the party will come back, reflect, and then redact less. Then, of course, you have 10 or 15% of parties which are there to obstruct, and whatever you tell them will not change anything. So it's only at the end of the process that you can address the difficulty.
Is there anything the tribunal may do at this stage when there is the confrontation by one party against the other regarding the, let's say, redactions or the legal privilege? Also, you mentioned previously that it's hard to check being on the opposing side.
As I said, one way is simply to have a hearing, small, short procedural hearing with the parties and confronting them. That can help. Right. Another way is to appoint a third, I mean, it has to be a big case, but to appoint a third party for the purpose of verifying that the redaction or the claim of privilege is valid. You can do that, but it adds to the costs and it adds to the complexity. But sometimes that's the best way. The case in which I did that was an investor treaty case of a certain magnitude. So I guess it was a choice of both parties to do it this way.
Mm-hmm. And I've had cases where we obtained an order requiring better details of why privilege was being claimed. And then we challenged that. And the case I'm thinking about, the case turned. The case revolved around abuse of privilege, and we obtained a favorable order overruling the claim of privilege, and it turned out to be a case winner order. And this can happen.
Yeah, that sounds like a great solution indeed. We have a number of questions in the chat. I think some of them were already answered, but let me read out this one. It's a question to both speakers. So sabotage and abuse in our reality are usually widely spread cases in practice. We need, I guess it's a question, do we need to be ready for them? So basically, are they the real cases in practice, or is it just the expectation, or is there just a risk that they may happen? And then there is the related question, what was the most memorable sabotage situation from your practice, and how had you dealt with it?
To deal with the first of those, I'll just be brief. I actually don't. I think it comes in all shapes and forms. I think sabotage is exceptional still. I think reading cases and reading about the practice of arbitration and talking to colleagues and going to conferences and getting more experience, all of those things are good protection for you. You know, the more stories you hear and the more input you get, the more you'll be able to anticipate impropriety later.
And
That's
what about the most memorable sabotage example?
You know, look, the trouble is I don't want to get personal. There's a couple I acutely remember, but I don't really want to encounter the people who did it again, so I won't comment about them. The misuse by sovereigns when you're representing an investor, the misuse by sovereigns of police or surveillance powers continues to be a particular concern of mine. I'll just leave it at that.
Yeah. And I fully concur with Tim. I mean, here we are discussing the pathology. That is the very topic of this session. So of course we are giving you examples, but outright sabotage is really rare because it means that you have sort of taken or cut your losses at the beginning of the case, concluded that you will lose anyway, and you would do anything to prevent the case from going forward or the award to be issued. So it is extremely rare that one party makes that determination at the beginning and then make the further determination to sabotage the whole thing, and burning your vessels and doing everything. It can happen, but it remains the exception. Now, in terms of the most memorable sabotage situation, we are, let's say, discussing real pathology here. So the worst situations, of course, are the situation where the party and the arbitrator appointed by that party are acting in concert. I'm not saying it happens frequently. It can happen on occasion. So then you get to fight against the party, the lawyer to the party, and the arbitrator, who is completely biased. And it doesn't mean necessarily that we are communicating with each other, but they're aligned. And that is good enough in sabotaging. And of course, the worst I had to experience was one arbitrator leaving the hearing. There was no transcript, we couldn't even prove it, claiming that he had a train to catch and leaving a hearing which was not going well for the party that had appointed him. That of course will paralyze everything, I have to say, but it's very rare.
And I don't, again, for various reasons, including that I never want to see them again, I'm not going to talk about the people who sabotage my cases, but the most notorious piece of sabotage ever, I think, still, is a case involving Indonesia.
Yeah.
About 20 years ago, maybe more, where on the eve of a hearing that was due to take place in The Hague, Indonesian government agents, I don't know if it was kidnap or coerced control, but at Schiphol Airport in Amsterdam, they intercepted the arbitrator appointed by the Indonesian party, who was due to be hearing the case, and persuaded him, by means, to return to Jakarta and never come back, leaving the tribunal with 2 members. The kidnapping case is, you know, it's taught at most law school courses on arbitration. And the moral of that case is that the truncated tribunal exercised an inherent power to continue hearing the case and awarded damages nevertheless. So it didn't work.
Yeah. The other thing I've seen this time as arbitrator is one arbitrator appointed by, let's say, a national company of a given country, telling us, I agree with you, but I will issue a dissenting opinion. Otherwise, I'll be liable on my own patrimony for the consequences of the award. In my country, there is a risk that they seize my house and go after my family. I don't know if it was true, but that was his excuse for dissenting. But this is real pathology, frankly.
Yeah, unbelievable. And yeah, it leaves me with mixed feelings, and maybe it's like a perfect final note, actually, because on the one hand, it's very reassuring to hear from both of you that it's still exceptional and rare, and sabotage and abusive process shouldn't be understood as something that happens on a regular basis in arbitration. But on the other hand, hearing those examples of how extreme it can get and how serious what serious forms this sabotage can take form sounds really alarming.
That can happen with judges too. I mean, this sort of thing, coercing somebody physically or threatening somebody can happen with judges. It's just a pathology of rendering justice.
Perhaps since we have still a few minutes left, we could maybe quickly discuss whether there is a ways to prevent the abusive process, specifically in document production. For example, is there something the tribunal can do while at the procedural order number 1 stage, or at the very outset of the proceedings, to kind of provide maybe more detailed framework or somehow prevent the risk of abusive process?
As a general matter, the more precise you are, the better in PO1, but I'm not a big fan of over-regulating, on the contrary, actually. But you have to, especially if you have parties or counsel not used to the process, you have to be very pedagogic, if I can say so. You have to explain each and every step, and possibly the consequences of not complying with each and every step. And that may prevent what I call inadvertent abuse. Now, if you have a party, again, having decided to sabotage the process, there's not much you can do to prevent it from happening. Then you have to find ways of dealing with it, in my view.
Yeah, I think it's when the disclosure order is made, which is not procedural order number 1, it'll be a later procedural order. The tribunal should avoid vague terms and should be precise in what it orders to be produced. And that, I think, it helps enormously. It should also be willing to receive submissions after production has been had by either party as to whether the production is full and complete. And I think one of the things that tribunals should do is they shouldn't always be simply satisfied with the party saying, I gave everything, right? Thank you, I gave everything. What more is there? Sometimes you need to insist that the producing party give details of the searches that it made and who the documents have come from and who was asked. So, sometimes, not always. I'm just saying it's in the follow-up that sometimes these things are important.
Yeah. I think I see that our time is up, so I guess that leads us to the end of which I think was very fruitful and interesting discussion. Thank you very much, Tim. Thank you very much, Philippe.
Thank you.
Thank you for everyone who was watching, and yeah.
Thank you very much.
Goodbye.
Bye.
Hello, good evening, good afternoon, and good morning. Welcome to the second panel of the day, State Bond, No Time to Define Investments. Welcome, and we would like to proceed with introducing our speakers today, our distinguished speakers. We have Josefa Sicard-Mirabal, who is an independent arbitrator and adjunct professor of law at Fordham University School of Law in New York, and also the co-author of the book Introduction to Investment Arbitration, published by Cleary in 2018. We have Greg Lourie, who is an associate at Cleary Gottlieb, and also previously with the Permanent Court of Arbitration. Greg is also the current ICC-IAF representative for Europe and Russia. Last but not least, Dmitri Evseev, who is a partner at Arnold and Porter based in London, and also the SEC board vice chair. I'm Crina Baltag. I'm an associate professor at Stockholm University, and I'll welcome you today to what is going to be a very interesting discussion. We have approximately 60 minutes for our panel, and we want this to be as interactive as possible. We will have a brief discussion among the panelists, but we also want to welcome questions from the audience. We'll make sure that we take these questions as they appear in our box. And of course, we'll reserve some time at the end for some further questions from the audience. Now, without further ado, because this is a very interesting and complex topic, the purpose of the panel is to try to grasp to scratch the surface of what investments are and where do we stay in the context of bonds and in particular of state bonds. And we have to start from the beginning, obviously. Salini test is one topic of debate that we're going to address today as well. And as you know, the Salini test suggested 4 criteria to be considered for an investment to be considered under Article 25(1) of the ICSID Convention: contribution, certain duration, risk, and contribution to the economic development of the host state. Now, the developing jurisprudence in investor-state arbitration within ICSID and non-ICSID cases has brought some additional elements or criteria to the Salini test. For example, in the Phoenix case, we had the Salini plus the investment to be made in accordance with the law and the bona fide character of the investment. Probably very interesting for our debate today is the Abaclat versus Argentina case, and in particular, the dissenting opinion of Judge Evseev. And in this dissenting opinion that will be greatly discussed today, we had a very interesting proposition that the term in Article 25(1) of the ICSID Convention, whilst flexible enough, is not indefinitely elastic. It leaves much latitude and a wide margin of interpretation and further specification to states in their BITs, but not to the point of rendering it totally vacuous without any legal effect. In other words, the term has a hard core that cannot be waived even by agreement of states parties to the BIT. And then the question for us today is whether bonds satisfy any definition, any notion of investment that we want to put it there. We also have the concerns with as I mentioned, the Phoenix case with the legality of the investment. We have concerns of bribery and corruption and so on and so forth. At the same time, we have new generations of international investment agreements who are proposing maybe a strict definition of the notion of investment following the Salini test, or they tend to exclude maybe specific reference to bonds. Now, that's enough introduction for us because our distinguished panelists will definitely delve in some of the aspects of my short introduction. And obviously, from what I summarized, the notion of investment in international investment law and arbitration, it's an evolving one, but also a necessary one. And we readily see that investments can take different forms. I mentioned that investment agreements are being amended, And arbitral tribunals are not bound by the doctrine of res judicata, stare decisis in investment arbitration, which means that a new tribunal can come and de novo have an interpretation of the notion of investment. On top of this, national courts tend to give their own interpretation of this notion, more recently in the Energo Alliance versus Moldova before the French courts. So, Greg, starting with you, please guide us through this maze that I just gave to everybody, and perhaps an overview of the notion of investment in investor-state disputes.
Thank you very much, Crina. And indeed, I think first of all, it is important to note there is no one notion of investment. And from jurisprudence of investor-state tribunals, we do see that it depends very much on the definition of investment, as you already pointed out. And indeed, we generally do distinguish between a subjectivist and an objectivist approach. The subjectivist being the notion of investment in the investment agreements, much of the BAT, and the objective one being the one in the ICSID convention. Subjective, so to say, because there is the intention of the party and there are more details provided. Well, in ICSID, we have the wording that an investment is, that it needs to be an investment, but not much guidance otherwise. So speaking about specifically about BATs, the definition of investment is usually extremely broad if we just look at the starting language. So usually almost every BAT says that every type of asset can constitute an investment, but then it is followed by a non-closed list of examples. And specifically this list of examples that is relevant in the jurisprudence of investor-state tribunals, and at the same time has quite developed, as you mentioned, over time in the way how investment treaties develop. So if we look at the so-called first generation treaties, for example, Soviet treaties from the end of the 80s or early 90s or post-Soviet states, the definition is usually quite short and is in one or two paragraphs. And if we look over the generations to the one developed more and more, they became much, much, much more sophisticated. And in some very recent agreement, we might even see a closed list definition. But let's speak specifically about bonds. So if we look at the definition of investment in, let's say, CSOB versus Slovak Republic, the Czech Republic versus Slovak Republic BAT, the definition of investment is generally as broad as it gets in the beginning. So also covering every type of asset, but then their examples include, for example, monetary receivables, something for the tribunal very important and stressed when deciding the case. It is, though, also worth noting that CSOB was, I think, launched in '99 and decided around 2004. So at this time, the discussions in awards were not as expansive and sophisticated as we have them right now. I think the entire award is about 120 pages. Similar in FedEx Venezuela, the same time, it was quite comparable. Now, moving on to later examples, there's, for example, the Democratic Republic of Congo versus US BAT, and there the African holding versus Congo disputes, where it was the fact that the examples included debt, which again was a strong basis for the tribunal's decision in favor of holding bonds to be protected investment. And then we come to Abaklat, which you mentioned before, and similarly there we see among the examples any right of economic nature conferred under law or contracts, and also obligations of public and private nature. Again, for the tribunal there, I'll come to speak about George Evseev's dissent later. The definition there being very broad and the example specifically public nature, quite helpful for this aim. So at that point, tribunals also focused maybe a bit more on the objectivist part of the double kilo test. So they would more look into the definition of investment under the ICSID convention and whether it would fit there, and there would be the broader discussion. So that's all before Pinsolle Banca versus Greece, which there denied that investment is that bonds are a protected investment. And it was specifically the language of the VAT there that led the tribunal to conclude that bonds are not protected. And to me, by the way, it was quite interesting. Crina, you mentioned that obviously there are no stare decisis in investment arbitration, which is true, and it obviously doesn't start us lawyers to argue individual cases and not only the language of the treaty and try to distinguish each case from the other. But it's interesting to me, and that's just a parenthesis, that tribunals tend to do the very same thing despite the fact that there is no stare decisis. So did the tribunal and Pinsolle Banca as well. And it distinguished that, for example, the Slovakia-Greece VAT speaks of any kind of as well, but it does not have the same specific examples that other tribunals found helpful. So, for example, it does not refer to obligations of private and public nature, the way we saw it in the Italy-Argentina VAT and in the Abaclat and cases. Is also does contain in the definition loans or claims to money or any performance under a contract. The interesting thing is that here the tribunal said that, well, the reference to contract is actually a very interesting point because it is a distinguishing element showing that public debt, which bonds are, is not protected, and public debt being quite different from a pure commercial contract. So in sum, I think what we can confidently say is that as far as the notion of investment is concerned, any kind of asset does not necessarily mean any kind of asset. And because bonds are not a typical form of investment where we have tangible assets or where there is a clear flow of capital, tribunals will apply the justum generis principle to determine based on the individual examples in the VAT whether bonds are protected investment or not. And on that note, I mean, being academic at heart myself, it was always interesting to me that while the bulk of academic writing, especially in the very beginning when CSOB, FedEx were decided, were leaning towards excluding bonds from the scope of investment agreements, well, tribunals didn't. And especially in the early days, there were also academics often sitting on these tribunals, arguably until today. And to me, in a way, that does make still a lot of sense because reading papers, you see frequently the arguments, I feel, are often based on broader policy consideration, or also try to encapsulate in general what states may have wanted or not, but only very few publications go into the detail of discussing and comparing individual language of BATs. So then, on the other hand, when faced with a claim in practice, one has to value the language of the treaty, which is also right if we look into the rules of interpretation under Article 31 of the VCLT, because the intention of the parties matters as manifested in the treaty. So, second, it is also quite interesting to me that states have repeatedly argued in and outside of the arbitral proceedings that they did not have the intention to include sovereign bonds when they concluded the BATs. And frankly, more recently, speaking of treaty practice, this is actually reflected in the more recent drafting of investment agreements. So for example, if we look at the Argentina-Japan BAT, which I think is of 2018, signed but not yet in force, it does expressly include bonds and debentures on one hand, but equally expressly clarifies that bonds and debenture excludes any kind of sovereign debt. Similar language also in the Australia-Uruguay BAT or in the Comprehensive and Progressive Agreement for Trans-Pacific Partnership that limits protection for sovereign debt to certain substantive standards. So one could here ask the question whether this is a move to restrict former broad treaties because they were concluded overly broad, or it means to clarify that what states' understanding was at the time when these first generation treaties on which many of these disputes were based were already handed by the states, but being less experienced in drafting the BAT was simply not put in a writing. And maybe last point to conclude is that national courts, of course, play an interesting role in the definition of investment. Since most decisions on sovereign bonds were under ICSID convention, they didn't have all too often the chance to opine on this specific matter. But to me, it was always interesting, speaking generally about the notion of investment and the role of courts, that domestic courts would review jurisdiction in many jurisdiction in full, which does not really correspond to the understanding that we usually have in arbitration, that there should not be a full appeal on the respective jurisdiction. And I think this is simply a remnant of the commercial arbitration origin of domestic arbitration laws. But when we saw this in courts, as you mentioned, in Argelian's Moldova case, it still concerned commercial debt rather than sovereign debt. But for example, there is currently the, I think the Gramercy Funds versus Peru case, which is a rare instance of an ICSID administered arbitration, but under the antitrust rules, and with a seat in Paris. So we might actually at some point in the near future see a decision of Parisian or domestic courts also on the issue of investment in sovereign debt.
Thank you very much, Greg. And we could hear that on one hand, we have this divide between the subjectivist and objectivist theories. We have the definition of investment with the Salini test we referred to, and perhaps going back to the dissenting opinion of the Judge Abisad, where he acknowledges that maybe the elements of the Salini test are not expressly laid down in the ICSID Convention, but it doesn't mean that they do not articulate in an imperfect way, perhaps, an obligatory requirement of Article 25 of the ICSID Convention. We also heard from Greg about the role of the intent of the party, the consent of the parties, and how the new BITs are trying to correct or not, or express the real intent of the states in defining the notion of investment. But let's stay with the Salini test. And Josefa, back to you. Let's take a more granular approach. We heard the elements, we heard some opinions of distinguished arbitrators. Let's look at the Salini test before anything.
Okay, thank you. I do want to preface everything by saying we hear objective test and subjective test. I think there's a little bit of subjective and objectiveness in each of the tests, whether where you're using the BIT or whether you're using the convention. So what do I mean by that? I don't believe that the investments are per se defined in BITs. I think that in BITs, what we have is a list of types of investments, but they're not really defined. When you say, loans, well, what types of loans? You say bonds, what types of bonds? What are they? And so when we go to the test under Salini, what is being provided here, although saying it's objective, it really also requires some subjectiveness to it, because to determine the contributions, which is one of the criteria, certain duration of performance, participation in risk of the transaction, and contribution to the economic development of the host state, none of that is actually specifically defined. So you have to use all of that to arrive at what is meant by investment, even under the BIT. And so why do I say this? I think it's really important. I think they go hand in hand. Why? Because one just has a list and the other one has criteria to be applied to define that list, whatever type of investment you're referring to that is contained in that list. And when you arrive at defining what sovereign debt is and whether it is an investment under the ICSID Convention, we have heard from different tribunals, we have heard from different scholars going both ways. And so there is no precedent, as we have said, but it really behooves us to look at prior decisions just so that we can sort of focus on ours, and we're not bound by them, but they do provide a sense of context. And so with respect to sovereign debt, this is the way that states raise funds for their needs. And so looking at typical elements of what a sovereign debt is, it should be as significant to the host state, duration, risk sharing, and then obviously profit and return is involved when you have a bond because they're regularly paid interest at maturity and or capital. But beyond those two, I have seen that other tribunals are also inserting a link to the host state and an association with a commercial undertaking. And so I think that the definition is sort of like geared towards the issue of the secondary market of bondholders, not just the original bondholders, so that it would be clear. And so those two additional requirements that are being thrown out there are making sure that the secondary market holders have some link to the territory, and also that it's under an underlying commercial transaction that ultimately will result in the development, the economic development of the host state. And I see that most tribunals that have implemented the Cellini test, which is that 4 criteria, have left undefined what the contribution to the economic development of the host state is. And if we look at the different criteria, we can see that the only one that is actually contained in the ICSID Convention is under its purpose and object is the economic development of the host state. So we need to look closer at how or which test, and by the way, different tribunals have added or taken away, but that the contribution to the economic development of the host state is one that is obvious, that is clear, that is contained in the convention. And it has been the one that has not really fully been defined as to what it is. Under Cellini, the tribunal said, well, yes, it is like a non-issue to say it is contributing to the development of the host state because it was an infrastructure project. So that was one. Now, that was in 2001. So fast forward, right? We need to look at what has happened now, what types of investments are actually taking place, how that can change the different criteria. They're all interdependent, and some may require a longer duration than others. But in general, I believe that the Cellini test provides a framework to define the list that has been provided in the BITs of the investments. That's it for me.
Thank you, Josefa. We'll go back to the issue of secondary markets in a subsequent question that I'll address. But before that, we could hear that from all of you so far that the Salini test was expanded. I mentioned this: investments in the territory, investments made in accordance with the law of the host state, the bona fide investment, and so on. Perhaps we pause here to think and to address in more detail the legality of the investment in general, and of course issues of bribery and corruption in this context. And I'll turn to Dmitri and ask for his kind guidance, summarizing perhaps the issues in this context, and if bonds can be tainted by illegality claims.
Thank you very much, Crina. The issue of legality of investment is a very broad topic. It's something that I've not only written about, but it's come up as a practical matter. It comes up in, virtually, well, I wouldn't say every, but certainly more than half of the investor state cases that I've been involved in. So it's something that's very, very important to the practice of investment arbitration. There are many related concepts here. There is, as you mentioned, the legality of investment in accordance with the host state law as provided under some investment treaties, whether the investment is legal under national law. But there's also the related question of whether certain kinds of illegalities constitute also a breach of international public policy, and also whether they might contravene public policy at the seat of arbitration, and to what extent that might be relevant to the job that the tribunal has. I mean, obviously, ICSID arbitrations don't have a seat, but for investment arbitrations that are non-ICSID, this would be a relevant consideration. So the types of illegalities that are normally discussed here are not minor technicalities of, you didn't comply with this or that, although I've seen it argued in a number of cases where, technically you had to meet these, technical criteria for an investment and you didn't meet it in accordance, and so it's not an investment in accordance with the host state law. But more typically, the things that tribunals consider in this context are serious, fundamental, wrongful acts of the investor in particular. And this, I have to say, is one of the only instances where tribunals will look at the question of whether an investor has done something wrong. I mean, investment arbitration is, primarily or almost exclusively about whether the state has done something wrong. So there's no opportunity typically for counterclaims. And so this is one exception where you do look at the wrongful acts of the investor and whether they've done something that really goes to the core, is deceitful, involves fraud or corruption. And bribery and corruption is obviously our topic also for today and part of Crina's question. It's certainly serious, certainly one of the most serious types of legality violations. And there have been a number of claims that have been, of course, dismissed on the grounds of corruption, and this number is growing. And many cases don't get to the stage of an award and in fact get withdrawn or dismissed. So it's actually only the tip of the iceberg, I would say, where these claims are actually getting to an award. Now, on the one hand, you might think it's sort of strange. It takes two to tango, and corruption is it takes two, both sides to be involved in corruption. There has to be a bribe giver and a bribe taker. And is it really appropriate for a state to raise a defense where there was an involvement of government officials? In fact, some countries only prosecute bribe takers rather than bribe givers. But of course, the notion is that bribe takers in taking the bribe are not behaving on behalf of the state, or they're acting in their own personal capacity, deriving in their own personal benefit. And so it shouldn't excuse an investor's conduct that there's some participation. There is a very strong sense, of course, that corrupt transactions should not be enforced under one theory or another. You could talk about bad faith. You could talk about unclean hands. Also, you could talk about a number of ways to dismiss a case that involves bribery and corruption, and all of these arguments, abusive process sometimes. So you can talk about it under different rubrics, but ultimately it comes down to proof often, and what you can establish and what you can prove. What standard do you need to meet? You have to establish, some tribunals have said, oh, this is a very serious allegation. You need clear and convincing evidence to prove corruption. Other tribunals have said, well, look, corruption by definition also very hard to prove because it's not out in the open. Parties take pains to hide corrupt activity, and tribunals don't have the same powers as the police or even an internal company investigation to uncover facts. So there's necessarily limited information available to a tribunal. So some tribunals have adopted a so-called red flags approach, saying, look, you don't need to prove corruption. You do need to convince us that it's more likely than not, that there was corruption. So 50% plus chance that there was, and you look at red flags, and that might be enough. Now, I've been, involved as an arbitrator in cases that have involved corruption, and I've had occasion to rule on these kinds of issues. And I have to say, my personal view is that you still need quite credible allegations of a scheme of corruption. You need to establish how the corruption happened. You can't just imply it from circumstances and say, well, this is obviously a disadvantageous deal, and this person is known to be an untrustworthy person, and therefore, this must be corrupt. I mean, you have to have quite a ways beyond that. You need to have evidence of specific corrupt activity, even if you can't fully trace the funds through all the bank accounts. Finally, with respect to bonds, I was initially sort of struggling to think of how this would apply in the case of bonds. I mean, obviously, you have your hypothetical scenario, but I do remember it was a case that in which I represented Venezuela. It was more than 15 years ago. In fact, did involve bonds and issue of corruption. In that case, it was actually fraudulent bonds. So the bonds were disputed insofar as the person who signed the bonds said that they actually never signed the bonds, and that a known forger had acquired the forms that this agricultural bank of Venezuela had, essentially forged the signature on these bonds and then started selling them and making loads of money. And then these various purchasers of these bonds came to Venezuela and tried to recover on them, in hundreds of millions or billion-dollar claims. So that was a kind of an unusual case, but certainly shows that illegality can come into play in cases involving state bonds, or in that case, alleged state bonds.
Thank you very much, Dmitri. We'll be back in another question to the issues of illegality, because obviously this is very important in the context of the definition of investment. But let's pick up on Josefa's reference to the secondary markets. And I'm going back to Greg because he mentioned Postova Banka versus Greece, a very interesting case. And in that one, the tribunal stated that although it has concluded that it lacks jurisdiction, ratione materie, and ruled in favor of respondent, the jurisdictional issue was not clear-cut and involved a complex factual and legal background. And in this not so clear web of elements mentioned by the tribunal, one was particularly raised by Greece, and that is the secondary market purchases of interest in sovereign bonds and the fact that they lack territorial connection, something that Josefa has mentioned already, with the host state. And this is a transaction that doesn't involve inflow of funds into the territory and not linked to a business undertaking in the secondary market. So let's pause here and address a bit in more detail this question of secondary markets and bonds, and how do they relate to the definition of investment?
Sure, Crina. So I think we need to look at it from two separate angles. So territoriality, say, and secondary market. To me, the initial question is about the territoriality of bonds as an investment, meaning in general, meaning whether the purchase of bonds is an investment located in a host state, is an investment located in a host state, or is required by most investment treaties. And indeed, for example, putting Paso aside for a moment, if we look at the Italy-Argentina BAT, there is such a requirement, but in literally almost every BAT has a requirement of that sort. But if we look at the earlier decisions like Abaclat, Ambiente, Fischer, and others, the tribunals have somewhat circumvented this discussion by referring to the fact that the benefit of the investment is in the host state, and that's what matters. And the idea was already there at some point in FedEx in Israel that found that bonds are not your usual investment, so you can't apply the same metrics as you would apply to a tangible investment where there is a good in a territory or an enterprise or similar. Hence, the state benefit as the criterion of territoriality. But is that indeed really a question of territoriality? And there's a good publication by Zachary Douglas that I came across when preparing for this, is that he said, well, if that's the case, then the purchase of Argentine beef from an Argentine state-owned distributor in Italy would be capable of constituting an investment in Argentina, or would be the same with a visa to travel to Argentina, et cetera, et cetera. Now, these examples would arguably not fulfill the other criteria of investment, which Josefa earlier mentioned, but on territoriality, arguably Douglas has a point. So indeed, especially in scholarly writing, these decisions and the idea of the benefit as a territoriality criterion was quite criticized, and for understandable reasons, because sovereign bonds are usually intentionally subjected to a law other than the issuing state's law in a jurisdiction of courts other than those of the issuing state. So in case of Abaclat, for example, the US law and court. So this makes it difficult to establish a territorial nexus to the issuing state. And in Abaclat, the majority was of the opinion that such forum selection clauses are contractual and therefore irrelevant for the purpose of a treaty claim. And this is a position that, for example, the dissenter, Josefa, heavily criticized for this, regarding the fact that bonds do have a specific configuration. And indeed, if you look into the rules of private international law, we'll probably go for the territoriality with the situs of the investment. For tangible assets, as I said, that is easier. For intangible assets, going by the rules of private international law, it could be, for example, where the bonds are cleared or deposited, but there is no such rule of private international law that looks at to where the benefit occurs. So this brings us to the secondary market issue. Are purchasers buying bonds on the secondary market making an investment at all, and if so, in the territory of the issuing states? Because states arguably do not benefit in any manner from the secondary trade of their bonds. So it's questionable if there is a contribution made at all when sovereign bonds are traded from one bondholder to another on the secondary market. And in fact, state has no benefit at all when the bonds are sold. So tribunals in the Argentine cases have applied the similar idea of the continuous credit benefit that is a benefit that continues to be transferred even if a bond goes from one bondholder to another, and the state continues to benefit also because arguably it would not have received any proceeds from the bonds because people are unlikely, and institutional investors are unlikely to buy bonds at all if they can't be traded. And this is all arguably true and is different from tangible investments that may be operated afterwards by the investor, but it does not change that much. The fact that it would not have been sold otherwise does not necessarily change the fact that they may simply not qualify from a territorial point of view or also from a contribution point of view as an investment. And to sum this up, to me, second market purchases and transferability of bonds are one of the decisive distinction between early cases like CSOB, where there was, or other cases regarding commercial debt, because the bonds stem from in CSOB from privatization of CSOB, and they were related to a specific product. Same in case of commercial debt, and there is simply a completely different territorial nexus if you're related to a specific project, as you have it with public debt, sovereign bonds that are just can be traded easily from one side to the other.
Very interesting. We'll address a bit more the issue of contribution to the development of the host state in a second. But going back to Dmitri and having heard more about investments made in the territory or the territorial link and the acquisition on secondary markets, I think let's put the reasoning of the tribunal in Hamester versus Ghana, who looked at previous decisions of arbitral tribunal in the context of the legality of investment and drew a distinction between legality as at the initiation of the investment, so made when the investment is made, and the legality during the performance of the investment. And here is a very interesting question. Dmitri said, well, it's not that often that you see issues of legality, bribery, corruption in the context of bonds, but would this distinction have any relevance in the context of bonds? And even what Greg has mentioned earlier, distinguishing between corporate and government or sovereign bonds. Dmitri.
Thank you, Crina. So I think it's fairly well accepted. I mean, maybe not universally, but the general rule is, I think, as you said, in Hamester versus Ghana and other cases, the idea is to look at, you define, the timing of the investment, and you determine whether the investment was made at that time in accordance with the host state's law, and whether there was some illegality committed at, after that point, could arguably be irrelevant to the question of jurisdiction, if we're talking about a jurisdictional defense. However, I think we have to say the case is different with respect to merits defenses, and oftentimes illegalities in the performance of or the operation of an investment would justify a state's conduct in taking measures against or not recognizing the investment. So it could well be a merits defense in there. But as far as jurisdiction, yes, typically it's considered at the moment of investment. The trick, of course, is defining the timing of when an investment is made, because it could be not one point in time, but many different points in time. Investments can be expanded. There could be capital contributions made. Oftentimes, let's say you've got a mining project and you have, one license, and then you have a license that's been extended, and let's say somebody paid a bribe to extend the license. That would be arguably, even though the investment's been there for 20 years or 40 years or however long, doesn't matter. If you are acquiring a right in the course of that, and that right is the one that's at issue in the case, then arguably you should be looking at how was that right acquired, irrespective of if there was a pre-existing investment or not. So, I think, you have to parse that question carefully in terms of timing and in terms of facts. In relation to bonds, I come back to the Venezuela case that I mentioned earlier. It also provides an interesting illustration in relation to timing. In that case, the purchaser of the bonds said, look, I purchased these on the secondary market. I was a good faith purchaser. I didn't know these were forged. Even if they are forged, it doesn't matter, because I was a good faith purchaser and I relied on various statements by government officials at the time that these bonds were in fact legitimate, and whether those were just poorly informed government statements or made by corrupt government officials who were paid off somehow for making these statements, that doesn't matter, because I was a good faith purchaser. I relied, and the state therefore owes me compensation. So that was, one of the arguments in the case, and it was interesting because it didn't depend on whether the bonds were forged to begin with or not. So yes, there can be interesting issues about what happens in the beginning, but also what happens later, and what conduct of the state with respect to ratification, recognition, acquiescence, etc., takes place. And I think there you have many different things to look at. As to corporate and government bonds, I mean, obviously in investment arbitration, you typically have sovereign bonds, rather than corporate bonds at issue. But I imagine you could have equally corruption or legality issues with corporate bonds, and presumably those would apply in a commercial arbitration, or otherwise if there was some state conduct involved in an investment arbitration.
Now, we heard that government bonds, sovereign bonds, are not always. Perhaps let's rephrase it. They might reach the opposite of contributing to the development of the economy of a host state. And the conclusion of the tribunal in FedEx versus Venezuela, I think it's a very interesting, because the tribunal said that they would involve a fundamental public interest. Now, the history shows that not always that's the case. So we go back, and I think this is a great comment to end with our discussion before we take at least one question from the audience as they're coming. Josefa, let's go back to the economic development of the host state. And the question is, just because they carry this fundamental public interest, is that sufficient to establish the link and satisfy the requirement of the Salini test? You alluded to this earlier.
Yeah, thank you. The answer is not necessarily. And why not necessarily? Because you need to look at, as I read, Weibull was saying that Schröer was talking about the effects So you have an investment, money is coming in. Let's assume that you do accept that sovereign bonds are an investment, and even in the secondary market, which I wanted just to say something to Greg when he was discussing how some cases have said that, well, it's an investment. It just like transferred from one to the other. So the benefit of the original investor is given to all the subsequent investors. So it's almost as if those on the secondary market are standing in the shoes, which is not the case. But that's a separate issue. As to the effects, precisely the secondary market bondholders are the ones that would sort of create the opposite effect in the market. And the reason is because as sovereigns, have debt, sovereign debt, though that's the way they raise capital. If they default, then there needs to be a restructuring of the debt. And that is where it doesn't necessarily benefit the host state to have sovereign bonds if at some point, then in the restructuring, the bondholders are not going to accede to that, but instead may be suing. And so I want to quote what the tribunal said in Postova with respect to the sovereign debt. They said, in sum, sovereign debt is an instrument of government monetary and economic policy, and its impact at the local and international levels is an important tool for handling of social and economic policies of a state. So while sovereign debt may be considered, or sovereign bonds may be considered an investment, it is not necessarily an investment that is recognized as such under investment, under ICSID. And also it doesn't necessarily contribute to the economic development of the state. And the FedEx language that was used is sort of like, it didn't even delve into what they meant. It said that the funds and resources were to undertake productive works, attend to the needs of national interest, and cover transitory needs of the Treasury. That was not very much explained, but it doesn't say how that would contribute to the economic development of the state. So it's something that needs to be pondered, because with respect to unsustainable debt and default and restructuring, it doesn't help the government if the bondholders do not accede to the restructuring. And as we read in the Postova tribunal, this is really impactful on the economic and social policies of a host state.
Thank you very much. I think we have time for one question from the audience, and one that came early and refers to returns. We haven't not covered this, but the question is, or at least rephrasing it, returns as investments. We know that the BITs usually cover this, but should we look at this as an interest? And does that mean that loans are also investment if we approach the notion of returns this way? Maybe Greg, I'm just
Sure.
picking up one of you. Thank you.
No, sure, happy to. So I think two separate issues here. First, some BITs may provide for returns as a covered investment, but quite often returns are also just provided as being protected. So the fact that that your returns enjoy a protection, that you are allowed to take your returns out of the state, etc., but that does not necessarily make them in and of themselves as an investment. The original investment as such would need to qualify, and that would then expand to the returns as well. But assuming, and speaking of the BATs that would have this kind of language, to me, it would probably go into similar direction as with Arbitrat or Pinsolle, to have a look what are the other examples. So if we're seeing returns primarily in the examples and the definition of investment being commercial, then returns can, or interest can very much be the from a commercial contract perspective, but does not, with all the reasons Josefa said before, cover public debt. So to cut it short, I would say that if we would be dealing with a BAT where we would say that sovereign debt is covered, well, then returns would be there too, and interest would be there too. If we come to a conclusion that it's a BAT where sovereign debt is not covered, the fact that interests are included would probably just suggest that it's interest from a commercial undertaking, but not from sovereign debt.
I see a nodding here, meaning that Josefa and Dmitri are in agreement. I think we have time for one last question. And actually, I would like to introduce that because I think it's the dissenting opinion of arbitrator or judge Evseev in Abaklat. It's a wonderful resource and something that we use quite a lot today. And the dissenting opinion says that referring to portfolio investments and other financial negotiable products, says such widely dispersed off-the-shelf financial products with their high velocity of circulation and their remoteness, the same as their holders from the state in whose territory the investment is supposed to take place, seem at first blush to be worlds apart from the direct foreign investment model, which is usually long negotiated and extensively embedded in the legal environment of the host state. This raises accurately the question of the conformity of these financial products with the requirements of Article 25 of the Exit Convention, and evokes a kind of informal presumption that because of their intrinsic characteristics, they're excluded per se from the convention. Greg has mentioned various examples of international investment agreements expressly now excluding sovereign bonds. We see also investment agreements also implementing the Salini test in the definition of investment, or maybe even a broader definition of investment with more stringent tests. My question to all of you to conclude our very interesting discussion today, in the context of the legitimacy of investor-state dispute settlement, should states do something in particular to be quite clear on what investments they would like to see covered by the treaties? I would start with Josefa.
Thank you. I think they should. However, that might be restrictive, meaning you need to be very clear as to what you're actually referring to that you're excluding. But with respect to financial instruments, they could detail what it is they do not want to include. It might be very helpful if they do express that.
Dmitri?
Yes, I agree. I mean, the issue of foreign direct investment versus portfolio investment, I think, is an important one to bear in mind. And it's true, I think, that investment tribunals in some ways have continually expanded the reach of investment treaties, I think, beyond the particular initially envisioned models when the first BITs were signed. But states are the masters of this process now. Ultimately, states can, negotiate new BITs, amend existing BITs, terminate BITs, and it does seem to be appropriate to take into account the jurisprudence of tribunals, and if it has gone beyond what the states had intended or wanted, then to amend or to include specific provisions excluding certain types of investments or clarifying what is meant by investment. Of course, it ends up, the process ends up producing further questions of interpretation of what is meant by the exclusion, and I think maybe that's part of what Josefa was referring to. But I think in any event, there will be plenty of work for lawyers like us to argue what is or is not in the scope.
Indeed. Greg, final word on this?
No, I fully agree to what Josefa and Dmitri said. I think from a legitimacy perspective, indeed, investment agreements have expanded, not the investment agreements, but the decisions of investor state tribunals have expanded some definitions beyond what states arguably contemplated when they drafted their first treaties. Their current treaty drafting is so much more detailed and sophisticated. So yeah, taking the example of the Japan BAT, for example, that I mentioned before, there are now treaties that expressly exclude sovereign debt from investment. And as Dmitri said, we'll probably end up arguing what exactly is sovereign debt, as we have argued in solar cases, what exactly is a tax. The same story will happen to us over and over again, and interesting times to come.
Thank you very much. Well, our time is up. Well, let me put it this way. I hope we had time to define investments, as the title of the panel says. I'm sure that there is much more to discuss, but obviously this is for another time. I would like to thank Josefa, Greg, Dmitri. I would like to thank the organizers for inviting us and for allowing the space to debate these very interesting issues. I wish you all best of luck, in particular for the moot, and I look forward to seeing you again. Have a nice evening.
Thank you. Thank you.
And
all.
thank you, of course, to our wonderful moderator.
Yes, thank you.
Thank you very much, Crina. Thank you very much to the organizers.
Yes.
Goodbye.
Bye.
Bye.